Morning, afternoon, or evening. This is Stephanie Joy with Joy Disability. You're about to see a replay of the live Q&A of a recent session. They are generally 1 to 2 hours long every Wednesday at 1 p.m. Eastern Standard Time on this YouTube channel. So I hope you get a little tidbit of information out of it. Otherwise, maybe I'll see you at 9 a.m. for short little workday shares that we put out there on a daily basis. Take care. Hi, guys. How are you? I'm Williams. Yes, I am very good. Thank you. I see a few people in there, a couple familiar faces. Good to see you guys. Yeah, I assume you can hear me, but if you can't, let me know. I think you can. I'm going to turn my phone off. So how is everybody doing in this whole last week? I'm doing great, in the scheme of things. And Williams, good to see you. He was our big winner of the last month, right? Yay. Yeah, I'm good. This has gone down a bit. The eye business is better after all those little things they put in there sunk down. So they're getting better. Definitely better than a few days ago. If you saw on Sunday, it was a little So we got Justin Yu. How's it going? Everything's just fine, Justin. As I said, Jane Barrows, nice to see you. Or Janelle, sorry. Furry's here. Nice to see you, Furry. Let's get to it. I see Dimple too. Hi, Dimple. Going to Janelle. Janelle has first question, the first actual question. Have you ever seen appeals counsel take longer than a year to either remand or approve a claim? Yes. And I'm not sure if I have one right now that is possibly a year. If not, it's very close. So it's usually less than that, Janelle, but in my experience, I can look at a status thing online that I have access to, and I don't know if this was always visible, but I was looking at it the other day, and where it says awaiting, and I forget the term for who's going to be looking at it. I don't think it was adjudicator. So, but it was awaiting something, and that just tells me it's waiting in line. That's what I think it's doing. It's not a priority case in the, under SSA rules. So that's probably why that is. I assume there's some that are priority. Like if the person's alleging terminal, they should probably jump on that one real fast. Dimple again. Yep. Okay. Thank you, Furry, for confirming that you can hear me. I just want to make sure I didn't forget, some button here. All right. Let's see. Kelly Kreis. I got it right. Right, Kelly? I know we're playing a little tag, right? Hopefully this week. And I see Maeve. Good to see you, Maeve. Chugging along we are, right? Janelle asks, can you explain the steps of an appeal after an ALJ denial? Do you get a date for them to look at the case, or do you only get a date if the case gets remanded? Yeah, they don't have like a deadline on themselves, Janelle. So following an appeal for appeals counsel is incredibly simple. You don't have to submit a brief. We do, of course, because we'd like to point out why we think there was remandable, appealable issues. But if, a lot of times a claimant pro se is not going to know what's really a legally appealable thing. They just know that they don't like the result and they think it was not decided correctly. And of course they want to know if, hey, can you remand this because he did something wrong that would make it legal where you can remand this? So you can do it right online under the appeals area. When you file for an appeal, it gives you that choice. And if you have more evidence that will be reviewable by the appeals counsel, and not all newer evidence generally will not, it's going to have to be missing stuff from the old case that there was a good reason why it was missing, perhaps. They give you an opportunity to, I think, link it with your appeal. Or if you only have it on paper, then you need to get it, or you want to have more time to prepare a position of why you think it should be remanded or reversed, which is very rare. You can ask for an extension right when you appeal it. You can say, I'm appealing it now. So you get your appeal in within that 60-day time limit, but then click I want an extension. And the fact that this is automated now like that is so great, because we used to have to do this on paper, try to fax it in, hope they got the fax, or mail it, certified mail, hope they got that. Obviously you have to do that way before the 60 days, right? Because what if it gets lost in the mail? It was a real nightmare. And then if you dispute that, it got there because you have a certified mail, but they don't have it, it could take 6 months or a year just to get that cog out of that wheel, to get that appeals counsel review going, or at least noticed. They do not give you a date for them to look at it. They don't technically have, I don't think, a deadline. Obviously, if they don't do things as fast as they can, they're going to get scolded by their uppers. But yeah, they're not beholden to you for a date. So you just got to wait your turn. Some people are going to, I presume, like I mentioned before, have a dire need or basis to be put to the front of the line versus the rest of us. Usually really good reasons. I can't really disagree with them. And yeah, you do not hear again from them. They may send you a letter acknowledging that they got your appeals counsel request and that they will be reviewing it. Or if you ask for the extra 25 days extension, they will wait, blah, blah, blah. When they make a decision, that's when you get your next piece of information. We decline to review, or here's our order. We are ordering it back to ALJ for further proceedings, which is generally a supplemental hearing. Okay. Sorry, I'm just scrolling down because I think I lost my place. Oh my gosh, it did scroll. So sorry. Okay. Kelly Christ says, completing my function report and referring to your video is very helpful. I'm now starting on work history, but kind of stuck on how to complete the hours spent on each task. Oops. So much for having the sound off. Completing my function report and referring to your videos is very helpful. I'm now starting on work history, but kind of stuck on how to complete the hours spent on each task. Yeah, Kelly, if you want to talk later today, when I get off of here and figure out where we were going when we were talking before or communicating or whatever we were going to do, if you're going to get representation, I would really prefer, I think it's better if you get help with that. She's referring to the fact that walking, standing, finger, using two fingers, one-handed, two-handed, all these little things on page 2 of each job of the work history report, the newer report format since June of 2024. It gets a little weedy, in the weeds, if you will. I do believe, Kelly, that now they have standing and walking together, which I think was very good. And then they're sitting. Generally, between the two of those, that's going to make up your full work time. Whether if you carve out an unpaid lunch, don't include that. So that would be a 7-hour workday, perhaps if you had or 7.5 hour. So I believe the standing and walking number and the sitting number would add up to whatever your total actual workday is that you're paid for. So that helps with those two up top, right? And it's funny, guys, speaking of that, I see people who had sedentary office jobs put 8 hours sitting, 0 standing, walking. We know that's untrue. Even the SSA knows that. So take advantage of the fact that you had some standing and walking. And that would be getting up to go talk to a supervisor if he said, come to my office, or going over to another person, or going to the copier, or you can have a desk job, but it is generally understood that it can involve up to 2 hours of getting up on your feet and moving around versus all 8 hours planted on your butt. Okay. I don't know why. I feel like my scrolling is like going out of whack. Okay. Dimple's in near Dayton, Ohio, and having lovely weather. We are too. It was a little on the cool side the last few days, but sunny, Dimple. And then today is very warm. I have my fan on above me. I don't have AC in this room. I have it out in the other rooms, but I have to close the door because I did put the green screen up today, guys. And those dogs, when they go crazy. Speaking of which, I don't think I put on my headphones. I think it's better for you guys if I put on my headphones, right? I'll put them on in a minute. Austin Yu says, when does the ALJ, whoops, if I get disconnected, guys, I'll connect back up. When does the ALJ judge start looking at your address, your evidence, I can't read, before a hearing? Well, that I think is going to be up to the ALJ in their office and how they do things, Justin, but I've heard different things. I've heard they have attorney advisors, first of all, and they're the ones that are probably definitely looking at it early on. So, like when you send in your appeal, I think in a perfect world, and I know it does happen sometimes, so maybe it happens all the time, perhaps sometimes more cursory than others, or for the reason that most aren't going to be able to do this anyway, just based on the merits of their evidence and the kind of case they have. They do a quick review to see if boom, boom, it should be an OTR on the record review and award. And we get those occasionally. They're not very common, but I love them when we do get them. And then when it passes that and they can't do that, then I think it's when all that time in between comes along. So if it goes through and then all that time passes, you're sending in more evidence. They might be helping with more evidence. If you need them to help you with more evidence that you requested and didn't receive, that they will do that. If I believe more than one day, generally a judge probably looks at his cases for the week. Every judge will tell you, I've thoroughly reviewed the case, and I guess it depends on what you mean by thorough, because I don't know that that's the case. I get the impression sometimes that it was not reviewed by the judge, who seems a little bit out in the field on it. But I'm not usually concerned, because that's the beauty of the hearing, and we can bring out our strong points. And because that judge is going to thoroughly review that evidence after he's heard what you have to say. So, and I'm not accusing any judge of not thoroughly reviewing it beforehand, but I do think in general, the judge's protocol is probably, no matter what, I'm reviewing everything again after I've heard what he has to say. He's going to have probably an opinion, and he wants to see if the evidence supports that based on what you said also. So there is often a post-hearing review, oftentimes. And it'll even say in the status something about post-hearing development, I think it might be. And that is probably when that's going on. And with assistance of, I don't think the judge is spending 10 hours a day looking at your case. They have a team, and different people have different roles, and that's how it can be done more expeditiously. But the judge that gets the feeling about the case with the testimony, the credibility, the issues brought up. I know some judges may not care about a brief, but I always feel like a brief where the main disabling components are noted, very concise, by the way, guys. When I say brief, I mean 2 pages max. I do generally that, but then I have an attachment. And that's how it's kind of like, my brief is only 2 pages. This is just an attachment, because I like to give the list of all the diagnostics, the ones that showed something objective, not normal, although sometimes those are in the list too, when there's normal findings. But because, back in the day, I'd be asked, when was there an x-ray on the ankle? Blah, blah, blah. And I'd be like, yeah, but I don't know when. Like, you know what I mean? So having it documented, because I'd have to say, I'll find that for you after the hearing, judge, so the judge doesn't have to go looking for it. But that's the beauty of the briefs. And I attach those things so I can always, I have them on the spot with me. I could tell him right there, but also he has it. So all the diagnostics that I think are really telling are right there on a list right in front of the judge's eyeball. So he doesn't have to go do, I don't know if they do OCR searches or what they do. And it's not the kind of thing I want to spend time. I don't want the hearing to be spent telling the judge where to find evidence. The hearing is about hearing from you about your day-to-day and your day-to-day struggles. That's the thing that isn't in the record. Yes, they have the function report from 1.5 years ago and your application where you may have made a couple comments and remarks, but that's not the same as hearing what's going on with you today. What has transpired since then, and where are your limitations now? How does your days go, right? Let's see, Maeve. I was told before that pending SSDI, I can go ahead and apply for early retirement at 62 to get at least some funds flowing. I have an appointment next week to apply via phone. And there's the second part, because the website doesn't allow it, which is perplexing if we're allowed that. What is the deal then? This doesn't mess up my claim, right? No, and I think, didn't we discuss this before? I thought you can absolutely file for early retirement before or after you file for SSDI. I don't know why they don't let you do it on. I don't know. There must be a reason, but I don't know what that is. But yes, you can absolutely collect early retirement. I always give the old caveat though, for those that do, be sure that you're willing to settle for that reduced amount, that early retirement amount. Should you prevail, you will prevail on your early retirement claim, assuming you're not working over the earnings limit for that. And assuming that if you lose your SSDI case, you will be stuck with that 30 or 35% reduced retirement amount for the rest of your life. So it is a risk, but sometimes we have no choice. We need that money because we haven't been working now for, a year, and we've tapped at our savings, which is horrible. We all work so hard to try to put away for a rainy day. So yeah, you can do it. It has that risk. If that's a risk you have no choice but to take. This is often true with single people. You need to have that money, fingers crossed, and really work hard to get everything done that would be best for the SSDI case, so that early retirement amount that you do get, because you are entitled to it if you are 62 or older, it's a big deduction. And if you prevail on your SSDI, for every case, every month that you should have been paid in retro would be owed SSDI, they're going to send you that extra balance. So let's say your SSDI is $2,000 and your early retirement is $1,300. Now they're going to owe you $700 for each of those months that you flipped from early retirement to SSD payments. That will not include the 5 months of the waiting period, however, if that falls in line with the months that you collected early retirement, because you're not collecting SSD for those months. So those will remain early retirement months. And those very small incremental reductions that apply to every month you take early would remain. But that will really, the flipping it to SSDI is going to eliminate most or a lot of, if not all of, the reductions from each and every month you took early. Okay, I hope that answered it. And it doesn't mess up your claim, not one bit. Dimple says, are you finding that initial filings are being reviewed quicker than they had been in the past so they can make decisions without the doctor eval or something like that? Brain fog is activated. Oh, I know you're referring to I'm trying to think of what that new upcoming thing, for a certain kind of case, they can make it without, until I look it up and have it fresh in my mind, Dimple, I'm not going to want to say it, but let me take a note on that because I could have sworn we mentioned this in something else too. I'm just going to see if I could take a note to trigger my memory later to try to get into that if I get some free time, and I'll do a little video on it. But that won't be the initial filing. That would be the initial review before they get to a decision. Because if it's going to be an award and it's a certain kind of case, though it's not every case, I don't believe. That's a pretty awesome new rule that if they see everything in that particular way it's described that meets it, they don't have to send it to the doctor, the medical guy internally, is my understanding. But I want to get it more concrete because that is a really good point, Dimple. So for a certain subset, it would certainly speed things along because you don't have to wait for the doctor to have the time to look at it, right? Not that they're necessarily the ones that are holding things up. I don't think it's that at all. But hi, Trish Wade. Nice to see you. Hey, Daryl Smith. Nice to see you back again. I got my SSA appointment rescheduled today after I sent the doctor the paperwork and medication I was taken from surgery yesterday. Why did they just ask for proof of the surgery? Is it normal? I got my SSA appointment rescheduled today. So you'll have a future consultative examination appointment. It was put off because you were having surgery. Is that correct? The proof of the surgery is not the more difficult part. The CE appointment is to see how you're doing. If you're improved well after that surgery, then there's a better chance that you're going to be found not disabled. You see? If they didn't wait, then they wouldn't be able to have a guy find that you are more improved. Or not improved, whatever. But, if you bounce back like a trooper, that could mean that the surgery worked. And the thing that was disabling you in your mind beforehand is now vastly improved. So that can obviously weaken your case. But I'm presuming that if you're vastly improved and the surgery works and you can go back to some sort of gainful work, you'd want to, right? RD says, hi, Joy. What does the DDS agent still call? Leave a message. Why does the DDS agent still call and leave a message and ask me to call her when she clearly knows I have an attorney? This is troublesome to me also, because I'm pretty sure there is a written rule that when there is an attorney or a non-attorney rep, we're all the same here, they're not supposed to go directly to the client. And I find it, do I dare say the word offensive? I don't really use that word. Overused and ridiculous. But I think it's ignorance some of the time. Their managers are not teaching them, but that is a no-no. And there's no accountability for it, so nobody gets in trouble. I have sent in a few spanking comments at times saying, because in my initial letter with my 1696 and fee agreement and all that stuff that goes in that connects me with my client, I have a paragraph. It's in every such letter that says, do not, I'm here now. You go through me. You do not call my client directly. My client has disabilities, including significant stress and other, fragilities. And the reason why they hired me is so that I can handle all this for them. So do not circumvent me. And I don't even know that they read that. Probably what I have to do is on the bottom of every, I think I have it in the one that I send the most, of every form letter that I, tailor to the DDS throughout the case, because I'm kind of in there sending them stuff on initial and recon the whole time. I probably have to have something not just in the letter, but boxed out in like a nice big red box saying, don't call my guy, that's, and I'll attach the rule because it is their rule. There's a reason why. I mean, I have seen underhanded questions from a DDS adjudicator to one of my clients, and I gave a severe thrashing by letter and got it in the file in their file. So it would be stuck in that file for that adjudicator to enjoy for the rest of the case. We did end up winning the case. But it was an inappropriate line of questioning to my client, and my client told me about it, and I was aggravated, and particularly when it was very inappropriate. And I don't mean in any weird way. It was them trying to get, I could tell she was trying to get something that would not be helpful to my client. So it was a little twisting. And, people are easily twistable. We all think we're so brilliant, and we are in our own way. But even the best of lawyers can be manipulated, particularly when it's something near and dear to your heart and you are subjectively, your head's all in it yourself. It's very hard to not see the twists as they come at you and just respond to them or react and answer without a forethought. Okay, Kelly, yes, let's do that. I will go through the email. I think I have your number. Daryl Smith, yeah, you're a disability veteran. Thank you for your service, of course, always, Daryl. Could I get a consultant because my lawyer is not talking to me? Here's the problem, Daryl. I have ethical rules that I have to follow as a lawyer, and I believe they would include not interfering with another lawyer's client matter. That could be very contradictory, and it's not really, I don't believe, within the rules. Like this is general. It's general information only, right? And that's a reason why I can't really do that. Know this about your lawyer. He has every incentive to win for you because he's not going to get paid for any of his time unless he does. And I don't know what kind of questions you're asking him because, if you're asking him, hey, why are you doing this? Why are you doing that? And how does this get done? He's not there to seminar you or take up his time teaching each of his clients how to practice Social Security disability. The reason why you hired him is for him to do it. I'm not saying that's the kind of questions you're asking, but we do see that a lot. And it's like, we don't have time for this. We're working on your case and that of others. So don't try to get seminared or free educational course. Go take CLEs. I mean, they have them now. They didn't have them when I started. We had to learn all this from scratch, from the sources, but they're out there now. They have their CLEs about basic Social Security disability and SSI applications and laws and how to do a case. They have the very basic ones. So, if that's something somebody wants to learn, and again, Daryl, I'm not saying that's what you're asking your lawyer. You probably have very good questions. And I do think it's difficult when some practices don't have a form of communication with their clients because it leaves people feeling kind of alone and out there. The portals, I can't speak more highly of the portals with high-end communication, and I love mine. So I can't do that, Daryl, unfortunately. Now, anyone can send in an eval form from the website. And that would be, which website? That one. Yeah. You could always send in an eval request, which you're not, and I know you have an attorney, so you're not going to really be getting an eval of sorts, but just requesting a review. I'll see that you have an attorney. But if there's general information, I would try to put out here in a video if you throw me a question. I get people sometimes who have already filed to withdraw their attorney. Now, I have videos on why you want to be careful if you do that, because you disconnecting the relationship with the SSA, because it's hard to get a new one under many circumstances. But I do review people who say, I'm getting rid of my representative because of XYZ. Would you consider taking me on? And that eval gives me the information to know if we even have an opening in the category you'd be in. So at least you could get, well, she can't take me anyway, so I'm just going to ride this out. There's that option. And then I can't do anything beyond that while you have representation, because it's interfering with that whole professional relationship. And that representative knows your case. I don't know it. I couldn't even give you, specific information without really digging in. You follow? So I don't do prepaid consultations for that because I can't. Give me 1 second. Okay, I'm having fun here with this banner. Okay, let's see. Where did we leave? Oh, it scrolls down right past me. These are going fast, guys. Second phone. How are you doing? Suggest are the specific names of the records I should ask for. In a previous video, you advised obtaining a DDE. What else should I put in the area? Second phone. I think he's referring, guys, to, did I skip something up above? Because it seems like it's cut off. Asking the SSA for a copy of your file. And if you are in the middle of a claim, whether it's appealing or whatever, it's in the works, whatever, you should get that for free. 1 copy. And contrary to what the 3288 says on it, they can't make you pick and choose which documents you get. If you ask for the entire file, they have to send you the entire file. I have the POMs on that. I have a generic, I have the 3288 where I have splattered on there, hey, you can't say this. He can ask this person, or I, because it's coming from the claimant himself usually, and usually I'm not even involved. Because I was involved, I'd be able to see his file in the electronic file. So I do this with people who are not my clients just because I think it's the right thing to do. And I attach to it the POM so they can read exactly. No, you can't make him pick and choose. How does a claimant know the name of these things or what they need until they see it? It's ludicrous. And I can't believe they get away with putting that in there and it hasn't been fixed, because their very own POMs, which I attached to it for their own edification, says they cannot do that. And it also says, and I put this in there, how if you ask for it to be emailed, they have to email it to you. They try to get away with, we'll burn you a CD and send it to you. A CD, what century are we in? First of all, most of them don't work. They don't work on Mac computers and systems, and they often don't work anyway. They become dysfunctional very easily. If they forget to send you the password, now you can't even get into it. And you have to have a CD reader. Who has a CD reader? Do they even put them in computers anymore? And then when they do, don't they break in short order? I mean, it's just crazy. So I would hold them to the rule. And, you know, there's even something in there that says, I believe, I have to look at it. Aside from the emailing section, there might be something that says they can upload it to your SSA online account. I mean, they upload other things like your benefits letter, your earnings statement. So don't know if they're actually doing that, but that is what I read. So, and I could have sworn I saw it in that POMS, but I could be mistaken of that part. But the email is definitely there. And they have to send it to your Yahoo or whatever email you give them. They can't say, oh, I don't like that one. That's a cheap free one. You know, not their business. You're an adult. You tell them where to send it. They should be sending it, right? I mean, you kind of have paid their salary. Okay, Furry says, if I have to pay out of pocket for medical devices, even though I have medical insurance, was there another part to that, Furry? Did I miss something? Well, you'll get to me. If I have to pay out of pocket for medical devices, even though I have medical insurance, this probably isn't your question, Furry, but could it be, this could be someone asking about, and I'm working and I go over SGA, can I use the stuff I paid, the amount I paid out of pocket for the medical devices to reduce my countable income for SGA to get me under SGA so I don't lose my disability or prevent my onset from being earlier if I have a pending claim or about to? Yes, you can. If it's a needed medical device, same with your co-pays for specialist appointments that concern your impairments. You can't deduct your premiums for your insurance, but you could do co-pays, you could do medicines that are out of pocket and medical devices that are, you know, probably not like a massage chair, although if it's prescribed, I suppose you could. But anyway, she wasn't necessarily asking that question, guys, but it is the same. Those words would often go with that kind of question. George Graham, how are you? And the praying mantis. Awesome. Well, yes, thank you for that, George. He says, good afternoon, Stephanie. Everyone hit the like and subscribe button. I have been told by a couple wonderful viewers that share time with us every week and in between that I should be saying that. So therefore, I got this banner that I figured out how to do today. But I wanted to also do this. I had the Stroudsburg High School, last day of school for everyone but the seniors, I guess. They're already done. And my son goes to Stroudsburg High School, so it's his last day. It was half day all week. And then this is for my other child. She's graduating high school. She went to CCA. This is not a paid advertisement, of course, but I want to just thank them. They got her to the finish line. She's been in CCA since 3rd grade, and now she's graduating high school with honors. Okay, but really, let's go here to do what I'm supposed to do as a responsible person on YouTube, apparently. But I appreciate it when you throw things out there, George. That's very kind of you. Okay, oops. I'm looking for the next question. Daryl Smith asks if a TBI is mental or physical. I believe it is physical. However, it causes mental health impairments oftentimes. So I would go with it both ways. That's just me. Amita, have you had any cases remanded due to ALJ not reconciling VE and DOT testimony? If so, did it end in approval? I have not, because we just won them all, so it didn't matter, and nobody else pulled it back. But interestingly, I have a supplemental hearing next week on a case that I'm not really digging it, because I was hoping the supplemental was because the judge wanted to confirm something with the VE in terms of the new rule about they can use many, many more sources, and they have a little bit more of the VEs, I feel like, have a little bit more leeway to have an opinion that's not strictly supported in a certain way, say such DOT or whatever, because now it's opened up. That's a late 2024 rule, I think, might have come into effect in early 2025. But so apparently, and my hearing was like, say, in October of 24, young person. This is where I'm concerned, because a colleague of mine at our last week's Zoom with colleagues that I have once a month, although I've been skipping months here and there because it's kind of getting a little dry. She thought that ALJ could be demanding the supplemental hearing because if he's going to deny, it could be an automatic appeal if he didn't, because he didn't use that new rule, which I don't know why he would have had to. But anyway, I don't know. I don't know. And I thought, oh man, I was hoping it was going to be a good sign for my youngster client, but maybe it's not. And it's just like he's got to cross all his T's and dot his I's to have an ironclad denial. I don't know. She has a good case. She's definitely disabled, but that under 50 can be a tricky one. And it's the kind of situation where she can't apply again. By the time she came to me, her DLI was practically up. I took it anyway, due to a categorical exception, but it's tough. Person deserves to win. Second vote says part 1, in completing form 3288. That's the form, guys, when you're asking the SSA to send you a copy of your file. In order to request one's full electronic file before email, via email, versus them sending a CD disk, which box do you check, number 8 or number 9? I don't have it in front of me. It says I could drag it up, but it's going to take me a minute. Yeah, it won't take me long. I've got it in my repertoire here. So I just sent it to someone the other day. All right, I'll show you guys. I'm going to try to share this, and I'm not good at this sharing. Oh, wait, can I even share on here? I don't even know how to. Sorry, I thought I was in Zoom. I'm not. Okay. 8 or 9, by the way, guys, this is where on 3288 it says, please release the following information selected from the list below. And then it goes on to say, check at least one box. We will not disclose records unless you include date ranges where applicable. And then it goes, 1 is you just want to verify your Social Security number. 2 is current monthly Social Security benefit amount. I mean, these are all things you can get online. 3, current monthly SSDI income payment amount. I presume you can get that online. I don't really know. Number 4, my benefit or payment amounts from X date to Y date. Number 5, my Medicare entitlement date from X date to Y date. Number 6, medical records from my claim folders from date blank to date blank. I would think that would be harder for them to start cherry picking all these things that, but no. And underneath that, it says, if you want us to release, this is about a minor child, do not use this form, blah, blah, blah. Number 7, complete medical records from my claim folder. So that part you can get. Number 8, other records from my file. And this is where they say what I believe they cannot say. And when someone has used this, or I've used this particular form that I've marked up, they end up getting the file that they want. It says, we will not honor a request for, quote, any and all records. So if you say any and all records, they will not honor it, they say. Or the entire file. If you ask for the entire file, they say they will not honor it. They put it right in writing on this form. And then they go on to say, you must specify other records. For example, consultative exams, award denial notices, benefit applications, appeals, questionnaires, doctor reports, determinations. Not true according to DI 81001.035. And this is in a big red box I put on that front page, and a little handwritten arrow up to it from where, and I circle what they said that they would not honor. I said, SSA is not permitted to restrict in this matter. And, quote, all documents that make up the case must be included, unquote. And that is a quote from that DI 81001.035. So what I generally do, if what I want is the whole file, I click 7 and 8 to make sure it's going to be all the medical records. And I shouldn't even have to do that. And 8, which is the other records. And by the way, underneath the other records, they leave a spot for you to explain what other records you want. And I say And then I have just some canned language in here that people can change where it says, including but not limited to DDEs, benefit applications, all the things they said above. In some, I include sections A, B, D, E, and F. Booyah. Like, come on. Your own rules say that you have to give the whole record. But that's what I do. Second phone. That's what I do. And I have attached to it. So if you need this, just email me. contact@joydisability.com. Give your name from here. Not that you have to. I give this to anybody who emailed me. So it's yours for the asking if you want that form with that little language thrown in there. Salvatore, Emma, I haven't seen you in a gazillion years. Hi, guys. They say, hi, Joy. If I see a new doctor since being approved for SSD, do I have to tell the SSA or do they automatically find out somehow? No and no. No, you don't have to automatically tell them. They don't want to know. And B, they're not going to automatically find out because they're not following you, your medical records. I'm not saying they're following you in any way, shape, or form at all. It isn't until you have a CE exam and you fill out, not a CE exam, a CDR, pardon me, and I got a hair in my eye. You actually give them an 827, the medical authorization release, same one you did when you were applying. That allows them, that's as if you have like a full-blown CDR and they're going to help get the medical records to help show that you have not improved enough to go back to work. So no, they don't, no. I'm sure some people in Uncle Sam would like to have that kind of invasion ability. Technically, right now, they don't legally have it. We are still highly private society, we'd like to think. But by rule, we are. So don't worry about that. I would just keep, I would keep track, keep your calendar so that later on, when you do have a CDR, if it has to go this way, you will have a list of where all you went on what days. And then you'll find yourself in an easier position providing any details that they want of when, who, all that. Daryl says his appointment was today. That's a CE, right, Daryl? My surgery was yesterday. Oh, yeah, you had it the day after. I think you told me that. The SSA CE exam is for mental health exam. I have physical exam next week. The surgery was biopsy to check for cancer. This is a new problem. Okay. I don't think there's a question there. La Lulu, nice to see you. Looks like you're doing a little yoga. Or gymnastics. I don't know, that cute little picture. I interpreted work history, the 3369 instructions, to list 5 years before you became unable to work as being 5 years before alleged onset date. DDS examiner said no, list past 5 years, 20 to 25. Your feedback? I guess you had a conversation with the DDS examiner, huh? Here it is. You can go with what the DDS guy says only because the form itself it is geared to everybody to cover all bases. So it asks you for the 5 years before you became unable to work, which would be your AOD, presumably. However, we know that in many cases, the majority of cases, the look back period is going to be 5 years from the date of adjudication. In your case, you're in 2025 getting adjudicated. So your adjudicator said just go the past 5 years because that's what he's got to look at. You don't have to go further. The reason why the form itself asks for the whole broad thing is because some people's cases, the look back period for prior work is not the date of adjudication. In particular, guys, this would be people who have a remote DLI from the past. Then it's going to be 5 years from before your DLI. So if your DLI was 2023, you're going to be 2023 back to 2018. So the form says it, and unless you hear the contrary, I'd go ahead and do that because you're not necessarily going to even know, and they want to make the decision of when your DLI is and when your adjudication and look back period is. They don't want lay people presuming they know the law, so they give the big broad and say, you tell us this. They're going to figure out from other things what your DLI is, of course, and if that rule about it being 5 years before your adjudication date holds, or if it's the other rule about the 5 years before your DLI, date last insured. Okay, so that's my feedback there, La Lulu. I hope that makes sense. R&D says, the DDS agent does not come up on caller ID. Well, what does it say? I will not answer my phone. Good, I don't, and I tell my clients not to. My attorney called the DDS and their voicemail was full. That's not going to be the first time. Yes, that's unfortunate. My attorney will send letters to DDS asking why she called. That's exactly what I did. So your lawyer's doing, I think, spot on and involved, and that's good. I had 2 cases this week where the DDS send out letters saying, please call me. It's very important. If you don't call within 10 days, we're going to go on everything we have now. And, because we won't have the information we're asking you about. They don't ask the questions in the letter, or at least give you an idea of what they want. And when you call, sometimes there is no answer. Sometimes it's a general number and you don't have an extension. Sometimes it is with an extension. So I called back because I don't want my clients having to call them. And I said, hey, could you, when you call back, can you leave the actual details of what you need? Because then we don't have to play this phone tag. Or if you don't want to do that, if you can fax it to me in writing, I'll get it right back to you. I'll get you every answer you need. It's kind of like, do you guys ever get it could be a phone call from whoever says, hey, this is so-and-so. I need to talk to you. Can you call me back? Or probably more appropriate, I just need to ask a question super fast. Can you call me back? Well, if it's super fast, why didn't you leave the question on the thing? I could have texted you the answer. No, I'm not calling you back unless you can get a wiser way of leaving a request, because it is so time wasteful. And in this kind of arena, every minute counts. It really does. I was kind of surprised. So for both of these people, I not only left a message back saying, can you do this? On the actual letter they sent, I put a little typed in note, dated it, signed it, and said, when you call back, can you please leave the details of what you want, or you can fax it to me at blah, 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 and you will get your answer very fast. In these busy times, I know you're very busy. I think I even put that on one, because you're very busy. I go, and so we don't have to play this kind of phone tag and take longer. Got a little twitchy eye. I think I need to eat a banana. What do you think? All right. Yeah, that's really disturbing. All right. Fredeberg. Hi, my friend. Hello, back to you. Is non-medical evidence possible to sway a decision during recon? I'd say that's not outside the realm of possibility. It's unlikely unless it's so incredibly riveting and objective. Like a non-medical could be a boss's letter, or suddenly all of your IEP information from elementary school and high school, that wasn't there before and really shows stuff. That could be. It could be a multitude of legal interactions, law enforcement interactions, where a person the symptoms are causing them to constantly be in trouble with the law. Like, and all those reports, those are non-medical, but they show that there's a maybe impulsivity problem, inability to use proper judgment, maybe becoming psychotic, all sorts of things, and how frequently it happens. So those are kind of like very strong instances of non-medical evidence, but it could be helpful. I hope you're not saying, Fredebug, that it's with no change in the medical evidence. Like, at least get updated records, I'm sure you're very diligently going to the doctors, right? And by the way, non-medical evidence, like my friend is going to write a letter saying how screwed up I am. That's probably not going to hold a lot of water, because your friend is not really an unconflicted person. Your friend loves you, and I'm sure telling the truth, but they're not going to take it that way because it is a person with a conflict of interest. They have a subjectivity. They love you, that kind of thing. But always get more treatment. And if on initial you decide, well, I'm not going to worry about my numbness and tingling in my hands, because that's not what I filed on, and it's not what took me out of my job. It was my severe back or my migraines or both. Go get those hands checked out. Get that new impairment well worked up on a continuing, ongoing basis, and it can do changes, because it gives the recon people a reason to not insult their initial adjudicator friend down the hallway for denying you, because now they can say, oh, there's all this new evidence that he didn't have. So I'm not like shafting his decision. His decision was right given the evidence he had. Now there's more evidence. This is my theory, that it can sometimes flip things on recon. By the way, we just had a win on initial this week. And by the way, guys, I think it went at least a year. Came out as a win, so that was awesome. Don't have any of the paperwork yet, but we are otherwise advised. So it's super, super great. But when you don't win on initial, if you have what you think is a strong case, get all that other stuff, those other impairments. I don't care what anybody tells you. Maeve says, by the way, sorry if we did talk about that. Taking retirement. My brain apparently ate. No, I don't get brain fog. Well, I thought I saw you ask for it maybe in the portal, and I really thought I responded. Yeah. But I wonder if this could be my brain fart, Maeve. Could I have had my answer, sometimes the whole answer, which could take this much typing, is in my head in 2 seconds, just because I'm deep into this stuff for so many years. And what if I said, I can't type that right now. I got to do this. So I don't know. I will check though to see if it was my brain fart or yours. But either way, it's all good. So you have your answer now. So that's awesome. You came on here. Daryl Smith. Oh, Daryl, yeah. My lawyer has never talked to me about my case. Would that be grounds to dismiss? First of all, anybody can terminate the relationship, you or your lawyer, and they don't need to have grounds. The only time maybe significant grounds would be needed would be by the lawyer if he's trying to dump you before hearing, after your hearing's already scheduled. That's a no-no. That's a newer rule too. So you never have to have grounds. I mean, you could be very generic. Like, I'm not even sure. They might ask you why, and you could just, if they do, I mean, I wouldn't get into being all mean or anything, but, just saying the communication is not meeting my needs or something like that. Intercommunication or interpersonal communication discrepancies that are not meeting my needs or something like that. Because that doesn't say that he's being a bad guy, and it's not saying that you are an overly needy person. It's not saying that either way. You know what I mean? So it's just kind of saying my needs conflict with the way that practice does things. That's all. I mean, there are people with heavy communicating needs, and we do a lot more communicating with them than we do with, there's some people that are just like, you roll with it, you tell me what you need when you need it, and I don't need to hear from you in between. So everybody's different. And we have our limits too, obviously. We can't, if someone wants to talk 5 times a day, it's not happening. And generally with phone calls, it's always at my discretion and when I think it's needed for the case. And otherwise, I'm like, if you have a question, somebody can answer it through the portal. And questions are always answered unless they're trying to be schooled on an entire subject matter, which is not the job we're hired to do. In fact, well, as you know, we're not paid at all at this point, so we're not going to be doing that. Second phone, what is the POMS I should reference? That would be that DI. Oh, I couldn't show you, could I? Okay. So under POMS, it is, the DI 81001.035. It's called copying a certified electronic folder, CEF, to compact disc, CD, or portable document format, PDF, which is where you get it emailed. But let me see if that's where. And then, no, where's the part about? The first paragraph of that second phone says, A, request for a copy of a disability folder. When a claimant, beneficiary, or appointed representative, because we stand in your shoes, right, requests a copy of the official file folder in either paper or electronic format, all documents that make up the case must be included. The official disability case folder consists of documentation per GN, blah, blah, blah. There's a link. Requests for certified copies of a CEF must be forwarded to the regional office. Yeah, you don't need a certified copy. You just need a copy sent by them. So the A is where it says they can't say, you can't say, give me the whole file. It's clearly contrary to their rules. And down below in B, C, D, E, F, there's the SSA policy that they can email the PDF of the file to the claimant. And also SSA policy to send claimant's PDF to SSA file folder to claimant's My SSA online account. I knew it was in there. But then I was thinking about it, I'm like, but are they actually doing it? That's why I was like, let me check if it's still in there. Anyway, I hope that answers your questions. POMS, it's that DI number I gave you. You could say the DI blah, blah, found in the POMS if you're going to reference it without attaching it. If you want to attach it, just go get it, print it out. I mean, I have it in a PDF so I could smack it up all over the place and tell them what's up. And I just attach it as on the back of my other PDF with the actual form, whether it's me asking for them or a claimant that I'm not connected to, it's blank for them to fill in their name and all that kind of stuff and where they want it sent to. Okay. Daryl says that he was able to get his CE exam rescheduled today. Okay. And that's just a reminder. I'll just tell you guys that CE exams, if you get a notice and it conflicts with a date because you have some other medical, let's say you have a specialist appointment and they're very hard to come by in a quick fashion. Sometimes you have to wait 6 months for your next one. You can say, I need to have this rescheduled. This doesn't work for me. I have a medical need that day or whatever. But you want to call them as soon as you get notice of that date. Sometimes they call you and set up the date with you. And that's probably the only time I allow my client to speak to, and it's generally not the DDS, it's their outsourced medical, whoever's doing their CEs. And that's the only time specifically to schedule it because it's their schedule that counts, not my schedule. It needs to be helpful to my client. If it's a 7 o'clock in the morning thing and he can't even get out of bed until 10, usually it's because there's something going on. They could be away at a wedding. I mean, people still go to weddings, or a doctor's appointment is a big one. I would say you try to schedule it when you're not, when you don't have a really important doctor appointment. Maeve says, I have CDs of several past MRIs. That's going to be the films, not the reports, because otherwise they wouldn't be on CD. Amazingly, I can still open them too. That CD question aside, I also have the paper results from these MRIs. That's the important part. And some old x-rays. Should I upload those to the portal? As you can see, me and Maeve communicate through a portal. Ding, ding, ding. The films, no use for them because they will order their own x-rays. The MRI reports is what the DDS will rely on. So whatever the interpreter of that report, the radiologist or whoever. And this is because our adjudicators are not radiologists. Neither are our judges. In theory, neither are some of the medical experts that work within the SSA, I suppose. So they're willing to accept generally the interpretation by a credentialed actual specialist who is the radiologist. Brandon H., nice to see you. After waiting a month for my consultative examination, I get a confirmation from the doctor Monday for the 5th. Okay. Tuesday, he sends me a message saying he got approved. I get a confirmation from the doctor. Tuesday, he sends me a message saying he got approved to change my appointment to the 23rd. Is this common? Yeah, if something came up and he has to change it. We just got one. I wouldn't say it's common, but it does happen because I just had one literally yesterday where my girl is scheduled for a mental and a physical and 2 different days. And the mental got canceled. Well, when I first heard it was canceled, I'm like, well, maybe they're saying that we have enough evidence and we've made our points and they don't need to waste the money on that because they're going to award her. No, they just rescheduled it because then we got another letter. So sometimes something comes up and for whatever reason, I'd have to think it's because of the doctor's office, not the SSA just choosing to wait. I don't think. I mean, why would they put it off? I mean, that alone costs money. They're doing letters. They're sending them out. They're putting letters up in the port, in the ERE, Electronic Records Express. Kelly Cray says, congrats to your grads. Well, okay, yeah, true. They're both grads in a sense. One just graduated 10th grade and the other one 12th grade. Crazy times. I don't know. La Lulu says, oops, she's talking to R&D. Sorry. Oops, didn't want to interfere in that. Oopsie. Daryl says, since I found your channel, I don't miss any of your videos. Oh, that's sweet. Can I give you a Google review? Sure. I don't know where that is. I don't follow that stuff, but by all means. I subscribe so I don't miss anything. Oh, thank you, Daryl. I appreciate that very, very much. Karen says, hey, Karen. Sandra Cruz. Ooh, Sandra just got approved today. You've helped me so much. Oh, I'm so glad. I'm so glad you got approved. I'm secondarily glad that I was able to help you so much. That's fabulous. That is everything to me being here, truly. Because if it wasn't so, I'd not be here anymore. I'm really happy for you, Sandra. That's really great. Sandra points out that it took her over 1 year. I mentioned the grid rules. I'm 60 with back issues. Yeah, they know about the grid rules though. So you guys don't even have to tell them about it. Remember, they've been in this business a lot longer than you've been involved in it. So don't worry if you don't know the grid rules and all that. They apply them automatically. Oh, Sandra's shaking. Oh, did you just find out today? Sandra, what's next? That will depend on whether you are SSI, SSD, or both. If it's SSD, make sure you did give them your banking information so you can start getting direct deposit. Same would be true for SSI, but with SSI, they're also going to have to do a perk interview to find out the finances and the living arrangements to see if you get the full 987 or something less. Yeah. So, and at that perk, I think you can give them your banking information if that was an SSI case. Karen says, my DDS called me. I'm in reconsideration. I think she's getting tired of the attorney. She probably is because he's probably protecting your rights. She was very nice and I'm worse from my first denial. So she got my new doctors, etc. Yeah, she's kind of breaking the rules there. So you got to always question. Remember, her job isn't to fight on your behalf. It's to make a decision based on the rules. But there are people with biases, I'm sure, even in the DDS, who might, for whatever reason, not want to award somebody, or they might be overzealous in their protection of the funds. Who knows? And like I said, the one DDS lady that called my lady and asked some really inappropriate questions that were not even really material but I could tell the DDS person actually didn't know the law as well as she should have. Which is possible. I mean, some of them are only been there a few years. You have an attorney, now I take that back. Attorney can give permission for them to call you. This attorney doesn't. I'm a real hard guy on that, but they can. So I do occasionally get a DDS person that leaves a message and says, can I call your guy? And I call them back and go, no. So reach out to me and let me know what you want, and I will get it for you much faster than you're going to have any success reaching my guy. Sorry, good. Look at these flyaways. I have a fan going on, I told you. All right. Let's see. Oh, yeah, it's kind of getting in my La Lulu. Sorry, talking to RD again. R&D says, thank you, Joy. By the way, your short video regarding frequent urinary issues was very helpful. I am the one with bladder mesh complication surgeries. Yeah, sections of my bladder was removed due to mesh erosion. Yeah, that's scary, that mesh stuff, isn't it? Christina, good to see you. Hello from California, she says. Glad you're here, Christina. Okay. Wayne C. Hi, Wayne. My question is, I've been 7 months in SSDI claim and I'm giving all my updated medical. Good. I have an upcoming ACDF, so he has a surgery, pretty serious one, level 2, second level, and I'm worried, so I decided to get a second opinion. Is this okay? Absolutely. I certainly do think so. Wayne goes on to say that he's 54 with 36-year work history. I'm wanting to make sure my surgery is absolutely necessary because I've already not been able to work for 10 months. I hear you. And surgery is very serious. So I think anyone who questions getting a second opinion has a problem. So I say, get your second opinion, get your, and then you got to weigh, like, there's always going to be risks. So a risk isn't always a reason not to do it. But if the chance of not improving or just being the same is significant, and talk to your doctor about it. And what's significant really depends. God, that's driving me crazy, guys. I'm sorry, but otherwise I'm going to roast in here, So I'll get a second opinion and ask all those questions about, I know everybody's different, but what percentage do actually improve and what percentages stay the same, relatively the same, and what percentage worsens? That's what I'd be asking. I mean, unless it's life-threatening needed surgery, that's what you kind of have to do, right? We have something along that line coming up, not me, my loved one. And it is kind of life, it's life or death necessary, which is always amazing because, but then you have to wait 6 weeks for the appointment. I'm like, really? How life-threatening, but it is. Delia. Oh, Delia. My DLI has passed and I just finished my ALJ hearing. If I'm denied, am I going to have a hard time hiring a lawyer for an appeal? Not necessarily. You would be appealing. Okay, so in Delia's situation, she says her DLI has passed. So the decision by her ALJ of the hearing she just had is going to be, if it's a denial, she has no choice. If she wants a possibility of getting Social Security disability, she has to appeal to the appeals council because there is no more opportunity to refile because her DLI is in the past and the judge's decision means everything up to the date of his decision is not disabled. You have to get it reversed or remanded. Usually it's a remand and then you go back to the same judge and he has to redo what they say he didn't do before he rendered that denial. Now, I think you should cross your fingers, Delia, for an award. My fingers are very crossed for you, my dear. The appeals council, a lot of lawyers don't do them. I don't know if they just don't know how to do them, and it's not that complicated at all. The problem is going to be that they don't know your case. I mean, you're pro se, so nobody's knees deep in. However, if you want to reach out to me, Delia, even though I was never knees deep in, appeals council appeals can be done when you're not knees deep in. There are some general questions I can ask without being thoroughly knowledgeable on your case that we could potentially find some appealable issues. Oftentimes the appeals council finds one that we don't even put in there. So one can do an appeals council appeal without an attorney, number one. And number two, even if the attorney doesn't know all the details of the case, the appeals council appeal can still be filed. And then if they remand, then you got a bunch of months for the attorney to get up to speed because now it's not, you got 3 weeks or, So think of that, just, you know how to reach me. We've done this before. Okay. But let's keep those fingers crossed and keep our chins up about you getting awarded on this one and not having to do that. You definitely deserve it, Delia. Okay. Redbone. Hello, I just subscribed. Oh, thank you. Love the helpful info. Can you please tell me what is the difference in SSDI and SSI? I recently applied. Man, this is hugely important. And we have a ton of videos on this. Redbone. SSDI is Social Security Disability Insurance. In order to have the insurance, you have to have paid for it. In order to have paid for it, you had to have worked for a certain amount of time over the course of your adult lifetime, and because that is how you pay those premiums. There's a Social Security tax that goes onto payroll. It's payroll taxes, and we pay them when we work, whether we are W-2 and it gets taken out of our checks, before we get the net, or if you're self-employed and you file your returns and you properly have to have had a net income from your self-employment. It can't be where you earn $10,000 and you expense out $10,000 because then you made zero. Had self-employment earnings that are taxed and you pay the Social Security tax over the years, you'll become insured. Now, at the time you become disabled, you had to have paid in for those premiums recently enough. I refer to this as kind of like term insurance. So if you paid taxes 20 years ago on 10 years of work, but you haven't paid in the last 15 years, you are no longer going to be insured because the maximum amount of time your term is going to go once you stop working, and this is the max. Some people can be less if they had more sketchy work histories in the last 5 to 10 years. But the maximum term, once you stop working, that your Social Security your insured status will extend out to, your coverage period, is 5 years, 5 calendar years. So keep that in mind when anyone delays filing because they just don't feel they need to, and they'll do it 10 years from now. SSI, on the other hand, is not Social Security Disability Insurance. It is not Social Security at all. It is supplemental security income. It is to supplement poor disabled people or poor aged people, aged meaning 65 or over. You do not have to have worked. You do not have to have paid in. It is pure welfare. It is a needs-based program. The definition of disabled, if you're under 65, that you have to meet is the same one as it is for SSDI, for the Social Security Disability Insurance. And of course, the poor factor is you don't have to be poor for SSDI. You can be a millionaire. You pay the insurance, just like you have car insurance. You get in an accident, you're going to make the claim. Same with Social Security Disability Insurance. SSI is different. So you have to be, and it is pretty low. We have some gripes about how low the resource limit is. And I would go on to say how low the income amount is too. But that's a story for another day. Delia, you're welcome. Okay, I think we're good, guys. Are we good? Are we good? Let me know if you have any other questions. I'll give it a couple seconds here, guys. We're doing pretty good. That's an hour and 15. Not bad. I like to get in and out. Sometimes we go, 2 hours and 20. Then usually my voice is gone, right? I can pop this up. Shout out. What did I do? Woohoo. Here's another banner. Prepaid attorney one-on-one consultations available. That is true, but only for the unrepresented guys. As I told Daryl, I can't interfere with a relationship that you'll have with your other hired professional. It would not be professional. But if you terminate, but again, before you terminate a representative, I said that will come on board for you. So that's what the evaluation is good for. We could say if you weren't represented, yes, I could probably, your category is open and I don't anticipate it closing, that kind of thing. Or if it is closed and there's a way, we can tell you that too, so that you know to look elsewhere before you discontinue the current representation that you may not be satisfied with. And then we have for your free eval, joydisability.com. Look in the upper left. There's a link, probably on every page, I imagine. But I'm just going to check if there's any more comments. All right, it looks like we're good. It is good to see you too, and have a great afternoon. I'm going to end this, guys. I don't think there's anything else, but y'all know how to reach me. On any video, you can ask a question, even if it's not entirely related to the video, because I know you just got to put them someplace. So, and if I can answer it quick, I generally will. If it is something that's a little more lengthy, I'll probably do a video on it. And usually what I'll do is if I know I'm going to, from seeing it, then I will, here's DJ. I will let you know that I'm going to have a video coming out. I just did one of those the other day. It's not coming out till next week, though. DJ says, I received my denial last week. Attorney sent me paperwork for reconsideration of denial. Okay. Any recommendations? My primary doctor is leaving his office in July as well. Set up a new primary ASAP. This is for anybody. When you're losing one, you got to have one. You have to have your doctors. Even if they're new ones, you can switch. Yeah. And keep following your attorney's advice. Treat. And updated diagnostics if you have. And just be, hopefully you have a communication way to get everything that happens to you, to your, relevant to your case, to your attorney, and just keep him apprised so he can use it when the time comes, when the appropriate time comes. And I'm sorry you were denied, DJ. It's rough out there. Wayne C. says, I recently also had a consultative medical exam, and it lasted around 10 minutes. The doctor did strength and range of motion. He said, you really have ROM issues, and I will note this. Was this good? He found positive things. So, yeah, I mean, whether it's going to be good enough for you is going to depend on your other medical records, all of your impairments, your prior work history, your vocational profile, your age, which is part of that vocational profile. Just to remind you guys, vocational profile, when we say that, is age, education, and work experience. So that's what I'd say. Fingers crossed for you, Wayne C. You're probably going to hear soon, because usually the CE stuff is towards the end, because they usually wait to see if they actually need one or if your medical evidence is sufficient to find it disabled. If it's not, then they generally send you for a CE before they deny you, or because it tips it over. Sometimes it's to confirm that, the records, they're very protected, but at least they pay for the CE, right? So even if it's a waste of time, you didn't pay for it. All right, guys, I'm going to cut on out of here. All right. I will talk to you later. Have a great week. I hope to see you every day at 9. Please do feel free to like, subscribe, share. And if you want to be a member, there are different tiers. There was something new I was going to add. I can't remember what it is now. Probably to the lowest one, but feel free to join. I'm going to take Marnie's. Sorry, Marnie. Sorry, everybody. One more, just because she popped it in here, and then I'm out of here. Will the SSDI payments be determined on my income exclusively, or mine and my ex-husband's combined income taxes? On yours alone. It's your work history, not his. Okay? All righty. It doesn't matter. It's about your work. You can have a non-work, think about it this way, Marnie. You can have a non-working homemaker married to a guy that makes $100,000. She's not going to have any insured status if she didn't work sufficiently. She's not going to be able to even apply for SSDI. I actually have videos on stay-at-home moms and dads, like, don't do it more than a few years. At least go get a job at the flea market on Sundays and willfully, file a tax return and declare that income that you made, even if it's cash, and pay the taxes on it. Because it's a shame when someone stays home doing the right thing, because I love being stay-at-home parent. I was a stay-at-home. I worked from home, so it kind of worked for me. But I'm a little bit of a think outside the box person since I was pretty young. And oftentimes something happens and they become disabled. The kid's now 6, 7, going to school now, full days, public school or private school or whatever. And mom or dad could get a job and they didn't. Or when the kid's even in the first 5 years, if you can do something to earn some income, because remember that insured status is going to expire within 5 years, and then something happens and they're not able to work. They get struck by some disease or condition or a big bad accident, and they got nothing, not a thing. So they had the husband pulling in the paycheck, but I tell you, it's helpful if both people pull in a paycheck, even if it's a small one. Very part-time, Marnie. It's still under $8,000 a year, and you get all 4 credits. You get the same amount of credits as someone pulling in $150,000 a year or $400,000 a year. You're not going to have the same benefit amount due from that because you paid lower premiums, but at least you paid the premiums. All right. Part-time. Marnie's saying she works part-time. Yeah, you're going to get paid based on what you put into the work life, not what your husband did. That's for his benefit if he becomes disabled or retires. Now, if you ever become widowed, God forbid, you can, if you wait till your full retirement age to collect it, that survivor benefit, you can get 100% of his. So you can eventually get his big amount instead of your own. But that's a long ways away, right? So anyway, La Lulu says, thank you. Liked, subscribed, and a benefactor member. Oh, yeah. Oh, you are. That's right. Thank you. All right. Bye, guys. I'm going to split it out because everybody is gone. Well, you guys aren't gone, but the questions are all done. You're welcome, DJ. I wish you had prevailed on initial, but keep up the good fight. All right. Bye, guys. I'll see you next week. All right. At 9 o'clock. The videos in the mornings. Bye-bye now.